Hello, and welcome to the panel NFTs, Use Cases and IP Implications, the lawyer's perspective. We've been hearing so much around NFTs lately and also during the day. However, I believe that there is still a lot of room to discuss areas which are still not quite visible. And one of them is definitely the legal areas around intellectual property, ownership rights, and taxation. And so far, I believe that IP hasn't really cracked down its real relevance so far. And I'm very much really looking forward to the conversation. So welcome, Michael, partner, Piper Alderman. Alana Kushnir, director and founder, Guest Work Agency and Art Law and Advisory Firm. And also Susan Corbisiero, director at Global Business and Talent Attraction Taskforce. So maybe, Michael, I'll start with you. Can you give us an overview of what are the implications from an IP perspective when it comes to NFTs? What we still don't know or we're still looking around?
Well, thanks, Dimitrios. And thanks, everyone, for being here for this panel. I can sense the excitement in the room when we're talking legals. Those with projects are always perking up going, just a question. As a lawyer, I've watched with great excitement around the NFT space, not just because a lot of NFTs, particularly PFPs, are much safer from a legal perspective than, say, utility tokens and other things that have been popular in the last 6 or so years. But the intellectual property aspect has been something very much overlooked for quite a long time. CryptoPunks is a perfect example of that. When it was issued, there was just nothing. No license, no terms. We then saw in a Discord some comments about, yep, we're going to adopt the Nifty license, which was used for CryptoKitties, and gave some commercial use rights. And then recently with Yuga Games' acquisition of the CryptoPunks IP, a lot of people sat up and said, hang on a minute, there's things being sold around IP. So I think that people are rapidly becoming aware that intellectual property is super important around any NFT project. We're starting to see some lawsuits emerge. I might speak a bit later on about the Peppy the Frog's Little Green Butt lawsuit that got filed last week in the USA. And will be a really weird precedent if that's our first precedent on NFT law out of the US. But really fascinating issues about making sure that the rights that are being sold by a project issuing NFTs are in fact properly sourced from those who created those rights, and that the people who are buying them actually know what they're buying.
So, Alana, you are working in an area with arts, which also we see a lot of high-value assets and also one-of-a-kind works. What is your perspective in relation to IP, which is a really, I think, very interesting connection here in the art space?
Well, I think, when we talk about IP, I think it's important for us to think about, well, what do we mean when we say IP? I think even that is sometimes maybe overlooked a bit, and I think in this space we really need to drill down into what IP is. I think one of the most common areas of IP that I hear of being discussed with respect to NFTs is copyright, of course. So you might be reproducing the image that is attached to the NFT, not necessarily the image, not necessarily the NFT itself, but the image. Trademarks as well. But also what I'm interested in, and I think this comes up a lot more with kind of unique NFTs or art NFTs, is these kind of associated legal rights that you have when it comes to intellectual property, and particularly copyright. So for example, if you are the owner of copyright, actually I should say the author of a copyright protected work, you also have certain associated rights, so moral rights. You have the right to be attributed as the author. So moral rights is an area I think that is important to think about. I don't think it's really thought about much. I don't think it's really kind of worked through much. Another area of law that we have in Australia is resale royalty rights. So I know one of the big kind of marketing spiels around NFTs is that the creator receives a resale royalty, but actually in Australia we've had resale royalty legislation in existence for a good decade. And in this legislation, it specifically identifies digital artworks as a type of an art form that resale royalties apply to. So that's just some of the areas to think about, especially in relation to unique NFTs.
And Susan, you are more into the commercialization and attracting talent here in Australia. What are the bottlenecks that you have been experiencing so far, particularly due to the lack of clarity in relation to IP issues?
Yeah, I'd start with a disclaimer that I'm not a lawyer. So, yeah, the way that we look at it, and I'm part of the Global Business and Talent Attraction Taskforce, which was set up basically around future-proofing Australia in terms of attracting talent and also making sure that we bring the right businesses in Australia to future-proof. So when I look at this issue of NFT and the IP, stepping back, I kind of look at it in terms of what we're trying to achieve in Australia and where we want to be. And I work particularly in an area about attracting digital games investment into Australia. And why this is significant is because in Australia, in the digital game sector, we've got a great creative sector, really good talent producing excellent work, but the sector hasn't grown. And that's historical because it's not been supported by government incentives. And what we're seeing coming down the line now, and something that I've been involved in, is the digital games tax offset, which is basically going to incentivise game production and development in Australia, and that's fantastic news. But also what we want to see as part of that is that we want to make sure that what's coming down the line and what investors, when they're looking at this market, are also looking at, okay, we want to make the game here, we want the creative, we want the technical talent, but we also want to be able to innovate here. So I deal with the AAA studios and also more so the emerging sort of disruptors in the space. And really, if we want to get the really interesting part of what they're creating, we want to be developing tech hubs here. We want to be able to let them innovate here. So all these issues around IP and what it means in Australia, they're really looking for clarity because I can sell them on come do the game development, but we want more than that. We just don't want them to create it here. We want them to innovate here.
Mm-hmm. That's a very good point. Now, the next question goes more to Alana and to Michael. So, imagine we have an unauthorized minting of an NFT relating to digital assets. What kind of potential infringements might people face, or whoever has actually done this?
Well, for an unauthorized minting, we'd assume immediately you go to copyright infringement if something's been taken to put up as a fake or a counterfeit NFT. And that's like everything in blockchain, there's always challenging points, and one of those around the authenticity of who has provided the actual art, which is connected to an NFT that's being sold, is really important. So, I imagine many in the room would be familiar with that, the Banksy NFT, where someone had been able to hack Banksy's WordPress site and put up a picture and then list it on OpenSea, and a Twitter user named Pranksy bought it and then was given back his money in classic crypto style of, haha, you fell for it, but have your money back. But that's a real issue because people are rushing around, particularly when there's a lot of speculation. So that kind of immediate infringement is there, but the real problem is usually who is doing it because of the pseudonymous nature of a smart contract setup and minting and trying to trace the funds. As soon as you go international on litigation issues, it becomes very, very expensive, very, very difficult. But you have businesses like Chainalysis and Ellipsis being able to track things in the normal crypto world and very rapidly in the NFT world as well, which may be of assistance, but there's an issue there. There's probably some other ones Alana could speak to.
Yeah, I'm also thinking about trademarks and consumer law. So I think a good recent example that's come up overseas is the Meta Birkins case, and the claim was filed in regards to that. So in a situation like that where you're working with already a highly established brand, they have IP in that brand, usually in the form of trademarks and associated rights with that brand. And so if you're minting someone else's content, you might not just be infringing in terms of copyright, but you might also be, passing off as being the authentic owner and rights holder of that content. So I think trademarks and consumer law as well. And by consumer law, I mean specifically misleading and deceptive conduct, which is actually very broad in Australia as well. So we can have a lot of types of conduct can fall under this misleading and deceptive conduct, consumer laws. So unauthorized minting might trigger that too.
And Susan, have you come across any issues when you deal with your customers in potential infringement issues?
That's probably getting a bit broader than the issues that I specifically deal in, but I think the key issue here is with the companies that we're talking to, is we're dealing with companies who are used to working in other jurisdictions. So particularly when it comes to the AAA studios, you know, they've had a publishing house here, they might have had a small development studio, but their footprint is quite different than what they've been doing here. And I think when we now look at this, you know, the space of NFTs and where you're minting and what you're doing and all the complexity of that, that just adds another layer of compliance and of understanding. So really our goal is just to make it more clear and give the confidence that Australia's heading in the right direction, and there's going to be some sort of harmonisation between, you know, all these different sort of infringements. Because, and the other thing is too, when you're looking particularly at the digital game sector, we're talking about, you know, in a sense, the game developers. You know, they're the big AAA studios, they're the big institutions, right? But what we're talking about here now, when we go into the NFT space, is changing the way the gameplay operates, but also you've got creators in the game now who are developing their own content or developing, who owns that IP, who's the infringement, what do you do, you know, as things develop to then be able to use that asset. So I think that's where the issue of the infringement, and I'm not going to get into specifics because I don't, you know, all the ins and outs of the law, but it's really looking at those issues, because you've got the company on one side and then you've got the players who are the creators. And they're in the game not to necessarily create their own IP. That's not their motivation of the broader game industry. They're in there to have fun. So when they're in there and then you're changing the way that they're interacting, or you're changing their motivation or their behaviours, then that's just about educating what people are doing.
Mm-hmm. Now, do different NFT marketplaces may impose additional governing issues and additional restrictions for NFT buyers? And if so, how can they do this? Maybe Michael. Yeah.
So I think one of the most common ways I've seen NFT platforms try to contain their users is by including a term in their terms of service or terms of use, which requires the user or the NFT collector to resell the NFT they might buy through the NFT marketplace, through that same marketplace, through that same platform. I think that's interesting from a legal perspective. I think that's worth being tested. If we look at, you know, contract law, for example, there are certain contracts that are not enforceable, that are not legally recognised, and those that kind of restrain one of the parties, they can come into question. So, you know, there's questions of fairness as well. So, you know, in this situation, we're really thinking of, well, you know, Can a platform really restrain a user, from a legal perspective at least, from going off and trading their NFT somewhere else? So maybe technically you could do that. From a legal perspective, there's kind of a two-way street at the moment. The platform is trying to restrict you from doing that through their contract with you, through their website terms of use, but at the same time, I'd question how, you know, if that's actually enforceable in practice.
And I suppose from my perspective, I'm seeing when marketplace businesses are being set up where they may be controlling the primary issuance, then it's a bit simpler because they'll often ensure that it's coming out under a standardised licence. So the users are aware of what they're buying. A big problem with OpenSea and other places is, again, it's the CryptoPunk issue. You can bring a ERC 721 in, and if the metadata doesn't link to a written licence, you don't have any real knowledge of what you've bought unless you're going to research it thoroughly. So the platforms have a risk that in deciding if they're going to whitelist or blacklist tokens to come in for sale, really should be taking care to understand what the licensing is around that. And there are some other ones that have looked to have standard licensing to say, most of them say if you're buying it from us, we take all care and no responsibility. And as Alana rightly pointed out, there's real limits in Australia. We have very, very broad and protective consumer protection legislation and unfair contracts rules to knock out parts of standard form agreements that aren't fair, and a court may very well decide that a clause buried in a terms and conditions that no one has actually read should be removed around that licensing point, particularly when you come to, as you mentioned before, unauthorised minting being done and counterfeits showing up, where the marketplace may very well profit from sales occurring in that. So increasingly marketplaces are having to go there and be a bit more proactive. We saw, say, the Turtle DAO was a great example where it was delisted from OpenSea because they had security-like elements, so not really IP, but similarly, I couldn't even count how many takedown letters I've politely sent to OpenSea in relation to projects where counterfeits have appeared. That's all we can do at the moment, is go in and say, here are the owners, here's how we prove the ownership, this is an infringing NFT. There's been a bunch where they've just mirrored them and plonked them up for sale, and it's a really fast way to knock up counterfeits, and in some cases it can look very similar and you have issues of passing off. Again, very hard to find the people who are doing it, and projects are very reliant on marketplaces to step in and be proactive about stopping that. That's a real issue at the marketplace side, and I think as we move towards more standardised forms of licensing, which we're not there yet, but I think Alana might be able to speak to, I think you're a bit familiar with the Koala proposed model. There's a number of standards floating around. The Nifty was the earliest one, but I mean, I always hold up Bored Apes as an example of a crazy license. It says you own everything in the art and the NFT, and then by the way, we give you a commercial license to do what you like with it, which of course is meaningless because if you own the copyright in the image you've bought, you don't need anyone to grant you a commercial license to do things with it. So there's, one of the richest projects around doesn't even have proper terms, and they bought CryptoPunks and said, now CryptoPunks is under that form of license, which might benefit from a rewriting. But if they want to give freedom to everyone and let that copyright pass, they still have to deal with issues around moral rights, and it'll be interesting to see it evolve. It'll probably take a few years to settle down and some lawsuits.
Right. Alana, you want to share a little bit about Koala?
Yeah, so some of you may have heard of the Koala project, the coalition of autonomous legal associations. And the model DAO last year was referenced in the Senate Standing Committee report that came out last year with respect to developing legislation for DAOs in Australia. But now they're working on a new project which is standardising NFT licensing. So I'm involved in that, and it's a really interesting mix of people because it's not just lawyers, it's also artists and technologists. So we're really trying to give a kind of a very well-rounded proposition when it comes to NFT licensing. And it's not just about working out, well, what is this license going to be and how's it going to be, as fair and equitable as we can be to everybody involved in the space, but also like, what about the technical implementation as well? So Michael, you mentioned before, sort of building the license into the metadata. How do you actually do that? So at the moment, it's very much a work in progress, but also something else I wanted to mention, and Susan, you talked about education before and the role of education. I think that's sort of been a subtle undercurrent of what we've all been discussing as part of this panel, and that is the role of educating the users and educating the community about their rights. I think when it comes to NFT platforms in particular, they do have a responsibility to their community, and part of that is taking on an educational role. That's just my opinion, but I think we still have a long way to go with that too.
And since Alana mentioned the word education, Susan, then ultimately then who would be responsible for doing all the due diligence to ascertain that the NFT has the actual rights that it should have? Is it the buyer? Is it the seller? Is it the platform? Who is everybody? Who would that be?
Yeah, I think it's a really good question because as different companies are developing, they're basically, what is their motivation and why are they doing the NFT? I can only talk from a digital games perspective. You're doing the NFT, if your goal and your motivation is connecting with your players, is having a game experience, then why you're doing it is really important to your communities and what you're empowering them to do. So to answer your question, I don't know, maybe all of them really in some respects, because it just depends what the service is they're providing and the value that they're giving to the people. Because they're not just going to fall for it because it's a fad. They're going to internalise it and have a value placed on it. And if you don't have a value on it, then I just don't see the whole point of it.
And maybe
I don't think it answers your question though. So.
I can throw an answer. It's anyone who doesn't want to get sued. So if you're a creator and you're selling an NFT, you don't want to end up like Paul Matt Fury and have someone suing you saying, I paid her. So this lawsuit was filed the other day. Matt Fury's the creator of Pepe the Frog, and he wanted to take it back from the people who were using it that he didn't like, so he made a series of 100, and he sold the first one as a one-of-a-kind, and allegedly made some representations that the other 99 would remain locked for some period of time. So a gentleman came and bought it for $500,000 US, and then subsequently 46 more of Pepe the Frog and his little green butt were sold. And so this $500,000 NFT's gone down to 30,000 in value. So he is sued saying, you represented to me that this will be super rare and super unique and you wouldn't be giving more of these away, and you did. Which goes, under Australian law would be squarely in, misleading and deceptive conduct and misrepresentation. So that's a really interesting case and pretty funny NFT to go look up as well. Just maybe don't do it at work. So that's an area that, from the creator side, oh no, he maybe has said something and tried to hedge it with, but I might change position later or subject to change or what have you. But when you get down to a judge deciding things, saying, well, why did someone choose to buy this? Were they relying on a representation that you should be held to as the issuer? The marketplaces will have exposure if they're listing counterfeits and not taking them down quickly, or having otherwise being taken advantage of, or allowing hacks to occur. And we saw an exchange announced this morning. They're bringing in effectively other crypto pairs and NFTs, which is great. They also then have the custody issues that come with that, where if they're holding someone's NFTs, it's a lot harder than custodying a fungible token because you actually need to know where that is. So the back-end custody is more expensive and higher risk if they're suddenly custodying Bored Apes. It's a very, very valuable thing that people might try and steal. And through to the buyers, well, there's always caveat emptor at some point. So when you're buying something, you should pay attention. If you're buying Banksy prints from a guy on the corner of the street in New York, there's a very small chance it's Banksy secretly selling them, but most likely it's someone with some fakes. And granted, Banksy's probably unlikely to come by and shut it down, but consumers have a role to play in understanding what they are buying. I appreciate, I'm probably the only one who reads, maybe Alana, the terms and conditions and licenses on these projects, and we love doing it. But as we move towards standardized licenses, it'll help people have an understanding and a summary of what it is they're buying, so they'll be able to make a smarter choice. At this point, we see people like sporting associations and bigger organizations issuing very comprehensive licensing, on one end of the spectrum, and then your Bored Apes on the other end of the spectrum, and there's a lot of excitement in between. But that's the part that I think leads to a lot of confusion for consumers down the track as to what they thought they bought. If they bought in haste, they may repent in leisure.
Brilliant.
What about then if you're someone who's inadvertently created something? Like when you're in a game, right? And you don't see yourself necessarily as, you're not going to read the fine print. It's just something that you realise has a value and it's a uniqueness to you. So when you're looking at those sorts of situations where you're not thinking about that broader, bigger picture of, this has got value that I'm going to on-sell, how do you kind of mitigate some of that?
Well, that's why the terms of whatever that game is needs to be really clear. Like if you breed an Axie or a Z-Run horse or something, you need to go and say, right. I mean, most people won't even think about it. They go, yay, I made a thing and I could sell it for something or use it in the game. But if there's a genuine, submitting some kind of art or design, you'll have hopefully some terms and conditions around that so that if you need them, they are there. In most legal contracts, at the end of the day, it's if you need them, you really, really need them. But many people get away without much being there because the market kind of works. And that's, so I'm not sure people will think about it too much, but hopefully the people who are operating the games and offering it up will have thought about it and will have those things in place in case there's trouble.
We have time for one quick question from the audience, so whoever would like to maybe ask one question, now it's your time. Yes.
The question was for existing brands who are coming into the marketplace and wanting to retain their IP rights, but also be community-minded. Yep. But there's a few experimenting in different ways. So I'm working with a few clients on some of those challenges. It's really different for each rights holder as to what they're trying to protect and what uses they're trying to restrain users from getting involved in. So the obvious one is like commercial use of an NFT after it's been bought. Displaying it in connection with hate crimes and things like that. There's some pretty obvious ones, but there's more nuanced issues. But very much the commercial use is the sensitive point there. It's just a process of finding out what the rights holder wants to keep and where they think the market will sit on accepting those limitations. But it's a dangerous place if the marketplace thinks that they're buying full rights to Birkin bags as little or other things. It's very tricky. So lawyers like Alana and I are in the thick of it trying to work that stuff out now.
Brilliant. So our time is up. Thank you so much, Michael, Alana, and Susan, for your insights. And I think we're going to be seeing a lot more going on in the space, but it's definitely something quite interesting to explore more. Thank you all for staying with us.
Thank you.